When Ketanji Brown Jackson joined the Supreme Court in 2022, she became the 116th justice in the history of that court. And all the justices have had different ideas about statutory and constitutional interpretation. Most of these ideas and philosophies fall into one of a few broad schools of thought about textual interpretation. And over the course of a career, a judge or justice may embrace more than one particular school. Different cases sometimes call for different theories of interpretation. Let's look at some of them. Like most other interpretive philosophies, textualism has evolved over the centuries. In its early form, textualism was a branch of legal formalism and advocated strict application of a statute's literal meaning in order to give effect to the will of the democratically elected legislature. Textualists contended that a court's failure to apply a statute as written meant that the court was exercising legislative power, violating the separation of powers doctrine. If the statutory language wasn't ambiguous, the court didn't need to construe it. Instead, the court simply applied the statute's plain language to the facts of the case. Strict textualism fell out of favor with most courts, including the United States Supreme Court, by the middle of the 20th century. But textualism saw a renewal in the 1980s, led by Justice Antonin Scalia, who joined the Supreme Court in 1986. This was often referred to as new textualism, which differs from traditional textualism in two primary respects. First, new textualism doesn't focus on the literal language of a statute or other text, but instead seeks to apply the word's ordinary, plain meaning. And second, new textualism is more receptive to the use of interpretive tools, such as the canons of statutory interpretation, to determine the meaning of texts that aren't plain and unambiguous.